Welcome to Ducks in a Row, the Estate Planning Guide.
Welcome to Ducks in a Row, the Estate Planning Guide with Attorney Erin Nunes, one of the managing partners at Surpenant, Beneski and Nunes Estate Planning and Elder Law. Erin and her team of dedicated legal professionals are helping southeastern Massachusetts families plan for tomorrow today. I'm your host, Lisa Mosbey, and I'm here with Erin to dive into wills versus trusts and what actually makes sense for your family. The team at Surpenant, Beneski, and Nunes Estate Planning and Elder Law are local experts dedicated to turning complex legal hurdles into clear, proactive roadmaps for adults and their children. Erin, thank you so much for joining me again today.
Thank you for having me.
Erin, people often get confused when it comes to MassHealth, Medicaid, and Medicare. What are the differences for Massachusetts residents?
So, Medicare is your government health insurance program. So, it's for individuals who are over the age of 65 or some younger individuals who have disabilities. And it's going to cover things like your doctor's visits, if you have a hospitalization. But Medicare does not pay for long term care services. And that's what Medicaid can pay for. So, Medicaid is what it is called federally. It's the same program here. We call it MassHealth in Massachusetts. But that is a needs-based program. There's lots of different varieties, but for most of our clients, when we are talking about MassHealth programs, we're talking about those programs that are designed to help support individuals stay home longer and bring services into the home, or help to cover the cost of long-term care if they do need to be cared for in that type of setting.
And I know we often think about what we're going to do as we retire or start to age, but what happens if someone doesn't properly plan for mass health, Medicaid, or Medicare?
So that is what we would consider to be a crisis situation. And, it really depends on a variety of different factors, what their family situation looks like, what types of assets do they own, what is the care level that they need. So it's really critical, even when you find yourself in that crisis situation, to make sure that you are sitting down with a professional to learn what options you still have at that kind of late stage of the game.
And many of us have heard the term 5-year look back. What is the 5-year look back rule in simple terms, and why does it make last minute planning so difficult?
So when someone applies for Mass Health has the right to look back into your financial records for 5 years. So they're really looking to see, have you given away assets in an attempt to, protect those assets or to otherwise make yourself become eligible for that type of program. So if you are someone who is inclined to try to, protect your home from the cost of long-term care, for example, you want to start that planning at an age and a health condition where you are likely to get through that 5-year look back period before needing care. So if you have not done pre-planning and you find yourself in that crisis or even nearing crisis where you think, gosh, I don't know that I can get through the next 5 years without needing care, whether that's care at home or care in a long-term care setting, that's where it can be really problematic because your options are much more limited at that point.
The story that comes to my mind in my head is that maybe you had steps when you raised your kids and you have a big house and you decide to downsize. And that downsizing falls within that 5 years of that crisis situation. And so I think many folks ask the question, do we have to be broke to qualify for help with nursing care costs? Or is there a way to protect our savings and our new home if they've downsized or our other assets?
So there certainly are. The earlier that you can start that type of pre-planning, the better. I usually recommend, once you start to reach like retirement age, because then you're going to have a sense of what your retirement income and expenses are going to look like. And that's going to help inform you about what type of planning options are going to best suit my lifestyle as I'm moving through my retirement years. Downsizing is perfectly fine. Assets that are used for your own benefit are perfectly fine. So if you need to spend to make repairs to your home for safety purposes, if you need to add a ramp, if you need to revamp your bathroom to put in, grab bars and other safety measures, it is certainly okay to spend your money to do those types of things. What is problematic is the giving away of assets. So, making large gifts to children or anyone really, that can cause problems if you then subsequently need care within the next 5 years.
And again, I think another myth that I often hear is it true that the state can take your house if you go into a nursing home? Or is that just a scary story that people tell?
Yeah, it's a little bit of a scary story. So even if you are a single person, you are allowed to own your primary residence and still qualify for Mass Health if you've met all the other requirements. If you've done some type of planning to protect it from the cost of long-term care, even better. But even if you did no pre-planning and you find yourself in a crisis and you need to go into long-term care, you can still own your primary residence. What happens is during your lifetime, MassHealth is paying for your care. And then when you pass away, that home that you owned individually has to go through probate in Massachusetts. And it's during that probate process that MassHealth Estate Recovery gets to assert its lien. So they're going to look back and say, okay, for the last 5 years, we've paid $400,000 for your care. We now want to be reimbursed for that. So before the assets can be distributed out to your heirs or your beneficiaries, MassHealth may be able to seek complete reimbursement or a majority of reimbursement for what they've paid out for you.
And if one spouse, let's say in a marriage situation, if one spouse needs nursing home care, but the other is healthy enough to stay in the home, will the healthy spouse be forced to move out or sell the house?
No, no, not at all. So in most cases, we would recommend transferring the home from joint ownership between spouses to the healthier spouse who remains in the community. That way, when the sicker spouse passes and Mass Health is looking for reimbursement, there's nothing going through probate, so there's no assets for them to collect against. So that's going to help protect the value of the home, for example, from the cost of long term care for the first spouse who got sick. But now, subsequently, the house is owned by the healthy spouse. And if they get sick, now we don't have another healthy spouse that we can transfer assets to. So, depending on their age and their health conditions, even if they did not do pre planning as a couple, that can really be a stark reminder of how important it is. And then they often will look to get their own 5 year look back period started to protect the assets.
And then I've heard of something called a Medicaid Protection Trust. Can you tell us what that is and how is that different from a regular trust you'd use or even different from a will?
Sure. So, the type of trust I think you're referring to is an irrevocable trust. And that is a trust that's designed to protect assets from the cost of long term care if certain provisions are included. So, generally speaking, in Massachusetts, the test that MassHealth uses when determining whether or not an irrevocable trust does its job and protects your assets is something called an any circumstances test. So, is there any circumstance included within the language of the trust where trust principle can be used for the benefit of the grantor? The grantor is the person who's created the trust and put their assets into it. So if there is some bad language in the trust that would allow for that, that means that the trust may not be protecting your assets from the cost of long term care. So with an irrevocable trust, what you want to feel reasonably confident about is that the assets that you're putting into the trust are those that you reasonably think you're not going to need to tap into in your retirement years. So again, for a lot of people, that's their home. They may have sufficient income or other liquid assets outside of the home that they could, fix the leaky roof or the water heater without tapping into the equity that they have in their home through a home equity line of credit or something along those lines. So that's really what someone gives up in an irrevocable trust in exchange for the protection that they'll get once they get through that 5-year look-back period. So with an irrevocable trust, you can generally change who your trustees are. In a good trust, a well-drafted trust, you can change who the underlying beneficiaries are if you needed to. But what you do give up is your right to tap into that equity that you have in the trust assets. Because if you could just keep reaching in and use it, as you could perhaps with a revocable trust, you wouldn't be getting that long-term care protection. A difference between
That
a
makes
difference
sense.
between the irrevocable trust and a will is your will only controls those assets that you own individually when you die. So if yours is the only name on a bank account, a car, your home even, those assets then have to go through probate before they go out to your beneficiaries. And your will acts as the instruction to the probate court on how you want things to be distributed. So in most circumstances, there is no asset protection component that you can achieve with a will that you could achieve with the irrevocable trust.
And then, Erin, let me give you a scenario. If a family is already in crisis, meaning a parent is heading to a nursing home next week, is it too late to do anything? Or can you give us kind of the highlights? I understand you can't be specific because it depends on every situation, but give us the highlights of what options are available to that family.
It's almost never too late to do something. So even if yourself, a loved one is, on the eve of a nursing home stay, I always encourage people to go and meet with an elder law attorney because they are going to be able to guide you through different options that you may still have. There are some exemptions to the 5-year look-back period rule. Again, spouses can transfer assets back and forth between one another. If you have a disabled child, you may be able to preserve assets by transferring your home or money to them either outright or in a supplemental needs trust. If you have a caretaker child, which is a child who has lived with you for at least the 2 years immediately preceding your needing long-term care, and essentially they were providing care for you at home that kept you in the community longer, then we can transfer the home to them and get it protected. So there are lots of different options that don't fit every family, but you just may have a caretaker child or a disabled child that you may be able to protect assets for. If those don't exist, there are still other last minute strategies like annuities or a special type of trust called a pooled trust that we can use. It's not going to preserve everything, I'll be honest, but if your goal is asset protection, it allows us to stretch the assets as far as possible in the hopes that there may be something to be left behind.
Erin, where I want to wrap this up today is can you share with us what is the biggest mistake that you see Southeastern Massachusetts families making when they try to DIY Medicaid planning?
Panicking. I know it's so easy, your mom, your dad, your aunt, your uncle, grandma, grandpa, whomever is ill. And it is so easy to panic. It's so easy to go online and just start searching up information. And, that can be dangerous and scary because not all of that information is reliable. So don't panic. Don't turn to the internet. Seek out qualified professionals who can take all of the scary rules that you've heard about and apply them to your specific situation and let you know what your options are. If you are a client of our firm, we have been building relationships across southeastern Massachusetts, Cape Cod, and the islands for 20 or more years. And we have really good relationships with other people who serve this population. So if you come to see us and we give you your legal options and you just don't know where else to turn, there are trusted professionals that we can refer you to get financial planning in place, to learn what your care options are going to be. So really seeking out qualified, professional representation during that time, that's the best thing that you can do for yourself.
Erin, this has been very insightful. I want to thank you for shining light on this and your guidance walking us through this process because it can be very confusing and all of us need to go through it at some point.
Yeah, absolutely. Absolutely.
To our audience, thank you so much for joining us on Ducks in a Row, the estate planning guide. If today's episode helped clear the fog on Medicaid planning, please like, share, and subscribe to help us empower more families across southeastern Massachusetts. Don't wait for a crisis to start your roadmap. You can find more educational tools or schedule a consultation at myfamilyestateplanning.com. As Erin at the team at Surpenant, Beneski, and Nunes say, the best time to plan is now. We'll see you on the next
Thanks so
episode.
much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.